Okay, so good morning. Today's daf is Bava Kamma daf ayin. I apologize that yesterday my email, on the screen accidentally wrote ayin tet when it meant samach tet. I wrote 79 instead of 69. So please forgive me for that. Also, I want to just mention for the record that Dove will be teaching tomorrow's daf, and so we will be Zoom only. So please keep that in mind. Okay, so yesterday we spent much of the day focused on Rabbi Yochanan's teaching, and Rabbi Yochanan is the rabbi of today. Rabbi Yochanan said that if a thief steals something, so let's say he steals this remote control from me, and he's now holding this remote control. So neither he, the thief, we'll call the thief, what should we call the thief? We'll call the thief Tom. Tom the thief. We call the thief Tom. Neither Tom nor I have the ability to sanctify this remote control. Now, here, when I say sanctify, I mean that we would donate the value of it to the Beit HaMikdash. The Beit HaMikdash would sell it and then be able to use the proceeds to maintain the Beit HaMikdash. So that's neither of us had the ability. And Rabbi Yochanan explains that the thief Tom doesn't have the ability because it doesn't belong to him, right? That makes sense. And I don't have the ability. We'll say in a moment. And I don't have the ability because it's not in my control. It's not in my possession. So that's the story with the remote control. And so the remote control, nothing would happen to the remote control. It would be, hidden, and we wouldn't know where it is until I catch Tom the thief and hopefully get it back. Then when I get it back, then I'd be able to be, to say sanctify it if I wanted to. So based on that, based on this concept, we're going to learn a law related to power of attorney. What is a power of attorney? A power of attorney is effectively a means of agency, a form of making somebody an agent who can thereby do what you have the power to do. You're never able, whether in Jewish law or in secular law, to give, in general, people power to do things that you can't do. But if you have the ability to do something, then you can give the power to your power of attorney. So, for example, the simplest example, or a simple example of a power of attorney, is when you give somebody the ability to engage in banking activities on your behalf, and there are forms that you can do. Or there's the healthcare power of attorney, so that they can make decisions on your behalf in connection with healthcare issues. So those are the different kinds of things that you might be able to do. But we're going to talk about a power of attorney to bring a lawsuit. Okay, can you make an agent to sue somebody to recover some piece of property? Now, we're not talking about real estate. We're talking about movable property. And let's take a look. So we're now the end of the first line on Ayin Amud Aleph, and we'll say Amri Nardai. The Nardayans teach, say Lokas Vinan Urkasa Amataltali. This Urkasa, which is basically the ability, we'll define it as a power of attorney. We don't write them for movable property. And Tosos here helps us out, that when we say that we don't write it on movable property, we're talking about a specific situation. Because before we learn this Tosos, we'll take a look at it'll be the second Tosos on Ayin Amud Aleph. Before we learn the Tosos, let's understand what the issue is. The issue is that I don't have the ability to transfer to. So we'll pretend that we'll do just again to make it more concrete. So I am trying to recover this remote from Mark, and I'm asking Stan to do it. Okay, and so, but when I ask Stan to do it, what I'm really saying is, Stan, I'm giving you the remote. and maybe I'm going to even sell it to you in order to write this document. I'm going to give you this remote, and now you're the owner of this remote. And but the remote is in Mark's hands, right? So the issue is that if we say that when somebody steals something, that nobody has the ability to be makdish it, to sanctify it, and donate it to the Beis Hamikdash, well, then similarly, I shouldn't have the ability to transfer the ability to sue to recover this remote to Stan. And that's what and Tosfos further clarifies that lokas vina and orkasa amataltali, davka amataltalin degazli. We're only talking about when it was stolen, because that's where Rabbi Yochanan has his teaching about amataltalin de pikadon. If I had just left this remote with Mark to watch it, well then kasvinan, we would write it, because daha tali time behektish, because everything is conditioned on my ability to make this remote hektish. Because a person does have the ability. If I just give this remote to Mark and ask him to watch it, I have the ability to donate this remote to the Beit Hamikdash. And so as the result, I would also have the ability to empower Stan to sue Mark in order to get it back. So the point is that it's only that when we say that there's no ability to write this power of attorney, we're talking about no ability in connection with a theft. So Amar Rav Ashi, Amemar, my time. What's the reason that you can't do this? So Amar Lei, Mishum de Rabbi Yochanan. It's all because of Rabbi Yochanan's ruling. To Amar Rabbi Yochanan, Gaza Velonis Yashu Habalim, Shneim Einan Yecholin Lahaktish. That when you have something that's stolen, Rabbi Yochanan says that neither the owner nor the thief have the ability to donate it to the Beit HaMikdash. Zelafi she'ena shelo, v'zelafi she'ena b'shuso. Because one doesn't have it in his possession, and one doesn't. It doesn't belong to one of them, and it's not in the possession of the other. And Rashi notes here, Mishum de Rebbe Yochanan, dehoel ve'enu b'rshus habalim, because it's not in the possession of the owner. Enu yachol lahakno so l'shliach. He doesn't have the ability to give it to a messenger, to an agent either. Hilkach im ava. Therefore, if it was therefore, if Mark were to return, if I were to send, if Mark was a thief and he stole this, and now I say to you, you be my agent and collect it back from Mark, and Mark gives it to you, and then it gets lost in your possession, I would be able to go back to Mark and say, listen, you didn't have the right to give it to Stan, because I didn't have the ability to make Stan my full agent, because I didn't have the ability to give this to Stan because it was in Mark's possession. And so as a result, I would be able to have essentially a double claim. I would have sort of like a guarantee until you actually delivered the remote to my hand. I would be able to say that to Mark that he still owes me the remote. Okay, so that's the first version of the statement, that we say that you're not allowed to write a power of attorney for movable property. But there's another version that's a little bit more expansive on where you can write a power of attorney. Amrei Nahardai, maybe the Nahardai didn't say what we said before, but maybe they said the following. Lo kasvin and urkasa amatalte de kafre. That the difference between this statement and the earlier statement is that last word, de kafre, that we don't write a power of attorney for movable property that's been denied, meaning that it's not just, if Mark admits that he actually owes me this remote, well, then I have the ability to empower Stan to go and collect it. Because time of the kafre, the mirse kashikra, that the reason that I can't appoint Stan to collect the remote from Mark, you're going to go back down? Okay, great. Enjoy. So the reason that I can't appoint Stan to collect the remote from Mark if he denies owing it is because it looks like I am lying. As Rashi says, fourth line in the wide lines, last of the wide lines of Rashi at the top of the daf, demechse, that it looks like falsehood, dechasminan ashikra, that it looks like the people who are signing the document that grants Stan the right to collect it from Mark, it looks like they're signing a falsehood. De Yahev le shliach midi de leisle gabi, that they are signing that something is being given to Stan, the agent, that I don't actually have, because Mark is denying the fact that he owes it to me. So as a result, it looks like some kind of falsehood. What's the implication? Avalo kafre. If Stan didn't, if Mark did not deny owing me the remote, and so as a result, we expect that Stan will be able to collect it. Kasvinan, we say that you would be allowed to write it. And why would you be allowed to write it? We'd say that you'd be allowed to write it because it's effectively a transfer on condition. That if, in fact, Mark gives the remote to Stan, now it's in the possession of somebody who's my agent. And so as a result, when it's in the possession of somebody who's my agent, now I have the ability to transfer it. So basically, what I'm saying is when this goes into your hands, Stan, it becomes yours. And so that I do have the ability to do. So those are the two views of this. So now that we have those two views, we're going to teach another rule regarding power of attorney that was happened to be taught by the Nardaim. So Amri Nardai, another teaching, Urkasa deloksiv bezil dun uzve va'apik lenashich. If the power of attorney doesn't actually say, listen, go sue in the Beis Din and win the case and take for yourself. Then lace mashasha. Then it doesn't actually do anything. Because why doesn't it do anything? My timer, mishum de amrle, haich, because the person can say to the agent the following: Lav bal dvarim didiat. I have no litigation with you. Meaning, when Stan goes to Mark and makes the claim for this remote, the issue is that Mark may be able to say back to Stan, listen, this remote belonged to David. Unless you can show me some basis for your claim, I am only going to litigate over this with David. David's the one who I stole it from. David is the one who maybe annoyed me or whatever. Maybe I have my own claims against David. I want to be able to litigate with David. And so I don't have the ability to transfer that unless I literally transfer the rights to this remote to Stan. Only if I transfer at this moment the full rights to this remote to Stan, now Stan can say, well, I understand all of that, Mark, but David gave me the full rights to this remote. And as a result, I am the proper litigant with you because I do have full claims to you. So Amar Abaye, Iksiv Bey, Lemechza, Lishlish, V'Ravia, Migu de Mishtoi Dina Apalga, Mishtoi Dina Akula. That Abaye adds that, you know what? I don't actually have to transfer the whole remote to Stan. I could transfer part of the remote to Stan. I could say, listen, because that Stan could say the following to Mark. Listen, Mark, I own part of the remote, and just owning part of the remote gives me the right to litigate with you. And once I have the right to litigate with you with respect to 50% of the remote, well, you know what? I have the right to litigate with you with respect to all of the remote. And so as a result, I don't have to actually transfer the whole remote to Stan. I can transfer part of the remote to Stan. Okay, so that's piece number one. Now we're going to have two further, effectively, and a debate about the story. Let's say, Amar Amemar, Itafas Lomak Pinamine. Let's say that, again, I tell Stan that he should sue, he can win the case, and he can keep for himself. Now, the question is, how much can he keep for himself? Do we assume that it's 100%, or do we assume not that way? So Amemar says that itafas lomak pinamine. If Stan grabs it and wins the case at the moment, we're going to assume, and wins the case with Mark, and now is holding the remote, do I have the ability to say, listen, Stan, that's right. We all know it's my remote. Or does Stan have the ability to say, no, you gave me the full rights to the remote in this power of attorney? So he said, so Amemar says that effectively you gave full rights, and we're going to assume that if Stan takes the remote at the end of his case with Mark, he gets to keep it. Rav Ashi Amar Kaven de Kasve Le Kol Demit Ane Mindina Kabilus Alai, because the regular language of a of a power of attorney says that I, the owner of this remote, am agreeing to pay for Stan's expenses with respect to the litigation. Shaliach Shaveh, actually, Stan is just my agent. So even though I've given him the ability to win to go and sue and win the case in court and to take this object, I have not actually given him the ability to own it long term. I've only given him the ability to collect it effectively as my agent. V'ika de Amri. Now, and let's take a look at Rashi. Rashi clarifies that Rav Ashi in the 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 13 and 14 lines down, Rav Ashi, Halagale de Amemar. He's arguing with Amemar. Again, Amemar says that Stan gets to keep the object. And Kavan Dixiv Kability Alai, so Alma Shliach Shavi. It shows that Stan is not, in fact, I have not, in fact, given Stan or sold Stan my rights to the remote, but rather he is just my agent. And Hilkach Itafis Mafkinamine. And therefore, if he grabs it, he's my agent. I have the ability to take it back from him because he's only my agent. He's not the owner of this remote. The Ika de Amar, and there are some who say Shutafa Shavi, that actually the story is that Stan is my partner. It's not that he does not have no rights to the remote, but he has partial rights. So Lamai Nafkamina, what difference does it make if the point is that Stan is my partner versus Stan is my agent? Well, the difference is Lamit Paspalga. What if he takes half of the item? So let's say instead of a remote, which is obviously a singular item, but it's a bag of wheat, and as a result of winning the case against Mark, Stan takes part of the bag of wheat. Do we say that as a result he gets to keep it because he's my partner, or do we say no, he was my agent and therefore I get the whole thing? But v'hilchasa shaliach shaveh, we say in the end that we're going to treat him like a shliach. Now, presumably, that's key. The key element of the fact that he's treated like a shliach is because the ordinary language of a power of attorney is that the principal, namely me, the original owner, accepts to pay the expenses associated with the litigation. And so that's why we're going to treat Stan only as my agent and not as my partner in doing it. Obviously, if we were to write the implication of all of this, and v'hilchasa shliach shavi, and we say that the halacha is that we treat him as a shliach, and so the upshot or a key upshot is that the language of the document will make a difference. So if in fact I want to give him a certain amount of it, I can make that clear. But if I say that he's procuring for himself, it doesn't necessarily mean that he gets the whole thing. It could be that that all I'm doing is telling him that he can collect it on my behalf. Okay, so that is a brief aside about powers of attorney, and all based on Rabbi Yochanan's statement. So now we return back to our original topic, which is the payment of 4 times and 5 times damages for slaughtering or selling an ox or a goat / sheep. So again, 4 times for selling a goat or sheep, or slaughtering a goat or sheep, and 5 times for selling or slaughtering an ox. Okay, so what happens? So Ganav al Pishnaim. We have 2 witnesses that say you stole the item. v'tavach u'machar al piem. And those same two witnesses also testify that you slaughtered or sold it. Well, that's an easy case. They're all the two witnesses are testifying to everything. Of course, you're going to have to pay the 4 times or 5 times payment. But al pi shnayim acherim. But even if two other witnesses are the ones who say that you slaughtered or sold it, mishalom tashlumei arba b'chamisha, will say that you also have to pay the 4 times or 5 times. So it doesn't have to be that the same witnesses saw that you stole the item and saw that you slaughtered or sold it. So ganav u'machar b'Shabbos. So now, and we're going to deal with that. That's going to be the topic of most of today. But the other topic that we're going to touch on today is ganav u'machar b'Shabbos. So I stole it, and or somebody stole it and they sold it on Shabbos. Now, if in fact they had slaughtered it on Shabbos, so then that would be presumably a biblical prohibition. And so as a result, we would have the principle of kimle b'derabamine, that we only apply the most severe punishment. And the most severe punishment in that instance is death, because, right, the person has violated Shabbat. So as a result, they would not actually be obligated in 4 times or 5 times. But here they didn't slaughter the animal, they just sold it. And sale on Shabbos, although you're not supposed to engage in commerce on Shabbos, is not actually biblically prohibited. It's only rabbinically prohibited. So therefore, we would not actually be subject to somebody would not be subject to the death penalty, and therefore he should still be subject to the 4 times or 5 times. Similarly, ganav u'machar la'avoda, if you stole it and sold it for slavery, for idol worship, So then you would similarly, it's not selling something for idol worship. Again, prohibited, but you're not necessarily going to but you won't get the death penalty. So to here, you're going to still owe the 4 times or 5 times. Ganav v'tava b'Yom Kippurim. What if you stole it and you slaughtered it on Yom Kippur? Well, on Yom Kippur, you're not subject to the death penalty. You're subject to the punishment of kares. Kares is not considered such a penalty that we would say that you only get the kimle b'derabamine, that you only get kares, but rather that's the penalty that you get from Hashem, but you're still going to owe the person the money. Ganov mishal aviv v'tavach u'machar v'achar kach meis aviv. If you steal it from your father and then you slaughter it or you sell it, and then your father passes away, well, then again you're still going to be subject to the 4 times or 5 times. Ganav v'tavach v'achar kach hikdish. Or if you stole it and you slaughtered it and then you consecrate the animal. In all of these cases, misham tashlumi arba v'chamisha, you're going to have to pay 4 times or 5 times. Okay. Next, we're going to deal with 4 more cases, and there's going to be a debate about the last 2 of them, Ganav v'tavach l'rafua. What if you steal it and you slaughter it not in order to eat it like an ordinary person, but you slaughter it in order to create some kind of cream or something like that, so that you can have some kind of therapy, some kind of healing. Or you slaughter it in order to give it to the dogs. These are not typical purposes for slaughter. So does that allow you to get out of having to pay 4 times or 5 times? We'll see. Hashochev v'nimtzes treifa. If you slaughter it and it turns out to be a treifa, so you're not allowed to eat it. Hashochev chulin ba'azara. Or you slaughter the animal and it was non-consecrated animal in the courtyard of the Beit HaMikdash, which is a prohibited action and makes the animal no longer kosher to eat. So then, nonetheless, the Tana Kamma says, Mishalam Tashlumi Arba v'chamisha, you're still going to pay the 4 times or 5 times. Rabbi Shimon poter b'shnei elu. Rabbi Shimon says that the last 2, the treifa and the temple, and the Beit HaMikdash, we're going to say that you're not actually obligated in the 4 times and 5 times, because you have that when we say slaughter, we mean slaughter in order to be able to eat. Now, while in fact you ended up slaughtering in the first 2 of those cases for a healing purpose or for dogs, Rabbi Shimon would agree that in those situations you could have eaten it, and so you're still liable. So those are the 4 last cases, and now we go to the Gemara.
And if it's pikuach nefesh?
So if it's pikuach nefesh, so the question. So let's see. So if it's pikuach nefesh, it's an interesting question. So, do we say a very interesting question that I definitely don't have all of the aspects of the Gemara at my fingertips on, but it's a very good question because we generally say, right, that pikuach nefesh, you're not various things, it can docha everything except for the big three. So here, all we're talking about is stealing. So it should enable us to overcome the prohibition of stealing. But the question then becomes, and I believe that this is a debate among Rishonim and therefore a debate in the poskim, that the question is, do you still then owe the item? And so, and of course, the other question that would be very interesting to think about is, when did the pikuach nefesh issue arise? If the pikuach nefesh issue arose before you even stole it, so then that would be where we would have this entire concept. But if in fact the pikuach nefesh issue arose only after you stole it, so then maybe you would not avoid liability for the 4 times and the 5 times if the reason that you slaughtered it was for pikuach nefesh, but you would still be liable for the 2 times because when you stole it, you had no pikuach nefesh issue. So those are some thoughts on that issue, but I don't have anything definitive. I do believe that we probably say, I would think that we would say that there would be liability, but there wouldn't be, the double payment or the 4 times or 5 times payment. Especially, one would hope that in that situation, one would take it, publicly. So that way, it would actually come before the court. You wouldn't try to hide and take it, because the point is that you're taking it legally. The interesting question that is dealt with is sort of that's analogous to the situation that you're raising, Ken. Is what happens if, let's say, there's a very expensive treatment that somebody wants, and they try to get the treatment, and the doctor says, no, I can't do it for less than $5,000, and the person doesn't have $5,000. And it's a medicine, so we're going to say that it's something that could be stolen. So would if the person then stole it, would the doctor have the right to claim, the pharmacist have the right to claim the $5,000, or something less? Or what would be the result in that situation? Not an easy case for sure, and certainly not one that I would want to suggest a particular answer off the top of my head. But it certainly seems like I would think that there should be liability associated with it, but you would hopefully be able to avoid the multiple payments, especially if you did it in a way that would be public, because then it would be gezela as opposed to geneva. So that would be there'd be a way to avoid the multiple payments because you just take it and everybody knows who took it. Okay. So I don't know that fully answered your question, but hopefully it answered it a little bit. Okay, so now the Gemara is going to address this ability to have 2 sets of witnesses testify, one to the theft and the other to the slaughtering or selling. So, Lema masnisin deloka Rabbi Akiva. Shouldn't we say that our Mishnah is not like Rabbi Akiva? De'i Rabbi Akiva ha'amar davar v'lo chatzi davar. Rabbi Akiva says that when witnesses testify, they have to testify to the full thing. Titania, as we have a brisa, and of course it's going to be, as often is the case, the end of the brisa that will get us to where we want to go. So Amar Rabbi Yosei, Kishahalach Abba Chalafta, Eitzel Rabbi Yochanan ben Nuri, Lilmod Torah, when my father Chalafta went to Rabbi Yochanan ben Nuri and to learn Torah, but Amrila, and others say it was Rabbi Yochanan ben Nuri, Eitzel Abba. It was Rabbi Yochanan ben Nuri who went to Rabbi Yossi's father, to Abba Chalafta, as we turn to Ayin Mabet. So Amrlo, he said to him, again, whichever way, one of them said to the other, Hareisha achla shana rishona bifnei shnayim. If what happens if I'm trying to make a claim that I have a chazaka on a piece of property, and the way I do so is I have 2 witnesses who testify to my own use of the property for 1 year. Shnayim shniya bifnei shnayim, and then the second year is in front of another 2 witnesses. Ushlishit bifnei shnayim, and the third year is also in front of another 2 witnesses. So mahu amar lo. So they responded, Harezo chazaka, that constitutes a chazaka. They can all be combined, and as a result, the person has shown that they in fact own the piece of property. So Amar lo apani omerkin, I would think so as well. Elisha Rabbi Akiva kolik padavar, but Rabbi Akiva disagrees. Shahaya Rabbi Akiva omer davar below chatzi davar. Rabbi Akiva says that you have to have a part of an item, not a full item. So Amar Abaye, afilu tamer Rabbi Akiva. Actually, we can say that even Rabbi Akiva would agree in this situation. How would we fit this with Rabbi Akiva? We would say the following. Milo Moda Rabbi Akiva, because after all, wouldn't Rabbi Akiva agree? Vishnayim Omrim Kidesh, Ushnayim Omrim Baal, to Aval Gav to Edi Bia, Sriche La Edi Kedushin, Kaven the Edi Kedushin, Lo Sriche La Edi Baal, Bia, Davar Karino Bay. After all, let's take a look at the following example. Let's say you want to testify, you want witnesses to testify that a woman has engaged in adultery. We need two things to be confirmed in order to make that work. The first is that we need to prove that the woman was married. So we have two witnesses that do that. But then the second thing, in order to make her subject, we'll need to say that she was warned. But the second thing that we need two witnesses to the act of adultery. Right. And so what happens? What would Rabbi Akiva say if those witnesses were not the same, that the witnesses to the marriage and the witnesses to the adultery were two different people? After all, if you only had the second set of witnesses that said that she had marital relations with, she had relations with somebody that outside the marriage, that doesn't tell us that it's adultery, because without the witnesses that say she was actually married, she can say I wasn't married. And so as a result, it's out of wedlock, but it is not adultery. And so as a result, but we do allow, and Rabbi Akiva would agree. And why would Rabbi Akiva agree? Because Rabbi Akiva would say, listen, let's take a look at the first set of witnesses. Do they need the second set of witnesses in order to be effective? And the answer is no. They don't need the second set of witnesses in order to be effective. Unlike the case of three sets of witnesses about being on the property for a chazaka. There, you need each of the three sets in order for the chazaka testimony to be a valid testimony. And you can't go in any direction and say that one of them would suffice. And so as a result, that's why so now let's see which case is more like our case in the Mishnah. Our case in the Mishnah involves two witnesses that say it was stolen and two witnesses that say he shechted it or sold it. Well, the two witnesses that say he shechted it or sold it, they certainly need the first witnesses that say the item was stolen, because maybe the guy was the agent and he was selling it as the victim's agent or slaughtering it as the victim's agent. So it could be that it would be totally illegal action. So it's only by knowing that it was stolen that we know that the sale or the slaughtering is illegal. But on the other hand, when it comes to the witnesses who are testifying to the thief, to the theft, they are a complete testimony. Their testimony is valid on its own, just like the testimony about the woman being married is valid on its own. And so as a result, hachinami, even though the witnesses to the slaughter or the sale, for that matter, would require the witnesses to the theft, we can, since the witnesses to the theft don't need the witnesses to the slaughter or to the sale, for that matter, therefore we can call it a complete matter. The first testimony could be a complete matter, and because the first testimony is a complete matter, we'll say that the second testimony is a complete matter. V'Rabbanan, okay, we now understand how Rabbi Akiva applies the principle of davar v'lo chatzi davar, but don't the rabbis also who disagree with him and who are the position that Chalafta and Rabbi Yochanan ben Nuri were testifying to in that brisa? So what's their viewpoint on when would it be that we're testifying to a partial matter but not a whole matter? What does that come to prohibit? So lemute echad omer echad begaba, ve'echad omer echad b'kresa. That if we're testifying about a woman's maturity and we're talking about her having the two hairs necessary, and one witness testifies to one hair in one place, and another witness testifies to one hair in another place, well, then that would be not good testimony, that each of them, that wouldn't be a valid set of witnesses. But one second, of course, that's not a valid set of witnesses. Each of those witnesses is not just a testifying to half a matter, but they're not even a full set of witnesses. So no, it's got to be where you have two witnesses testifying to one hair and two witnesses testifying to the other hair, and as a result, because they're testifying to hairs in different places, and those two hairs are being combined in order to make her an adult, each of them is not testifying to a full thing. So Hani Amri Katanahi, and so as a result, each of their testimony leaves the woman as a minor. Vahani Amri Katanahi. And the other witnesses are testifying to something that would leave her as a minor. And so as a result, in that situation, we won't combine them to say, oh, it must be that she's an adult. Okay, so that is the story with respect to Rabbi Akiva and how Rabbi Akiva can even be consistent with our Mishnah. Now we go to the issue of selling on Shabbos. So Ganav Makar B'Shabbos, that's what we said in the Mishnah, that of course you are subject to the 4 times and 5 times. But we have a problem because Vahatanya, we've got a brisa, a putter that says that in that situation, if you steal an animal and then you sell it on Shabbos, you are exempt from having to pay the 4 times or 5 times, which implies that somehow in this sale, you were subject to the death penalty. So how could that be? So we're going to have 2 answers. We're going to give one answer, and then we're going to reject it, and then we're going to give the second answer, and then we're going to come back to the first answer. So Amri Rami Bar Kamma, Rami Bar Kamma, Rami says that the following. He Tanya Hahi the putter. When is it that the brisa was talking about that the thief is going to be exempt? But Omer lo, when the buyer says to the thief, Akot slicha, Akot te'ena mit'enasi, you cut off a fig from my fig tree, v'tiknei li gnevasech, and through doing that, you'll sell me the stolen animal. So as a result, it's the act of taking that fig off the fig tree. That is a biblical prohibition on Shabbos. You're not allowed to certainly purposely cut a fig off a fig tree. That's collecting the food, collecting the crops, and and removing something from the earth, and that's going to be a problem. That's going to be a biblical prohibition. So Amre, 1 second, is that really a good transaction? However, the kevan dechitava le kaman bedina lo amrinan le zil shalem. If in fact the thief refused to hand over the sheep that he sold by buying it through taking off the fig, the court would not enforce the sale, the mechayev b'nafshahu, because he is already subject to the death penalty in that same act. So hamachira nami lav machirahi. So shouldn't we say that sale is not a valid sale? And so as a result, that can't, if it's not a valid sale in the sense that we wouldn't enforce it in a court of law, it shouldn't be a valid sale to make one subject to the 4 times or 5 times penalty. And if they're not subject to the 4 times or 5 times penalty, big deal that they're putter from the 4 times or 5 times penalty. They're not subject to it. So Ela Amarava, Rav Papa. So Rav Papa gives a second answer. So, and what's the second answer? But Omer lo zrokenivuseich lichatzari. Throw the animal, what you stole, into my chutzar. The tiknele b'gnevusech, and through your stealing it, I'm going to take acquisition of it, and you'll acquire the money that I put aside for you. Kaman, who is this like? It must be like Rabbi Akiva to Amr kaluta kamisha hunchadami, that when something is in the air space, it's as if it's on the ground already. To Ikarabanan, because if you say that it's the rabbis who disagree and say that when something is in the air, it's still in the air, and until it lands, it has not landed. Kaven demacha lechatzer beso kana. As soon as the animal goes into the buyer's airspace, the buyer has acquired it, because you can acquire things in your airspace. But le'inyan Shabbos, but when it comes to Shabbos, lo mechayev adamacha la'ara, he won't be obligated to the death penalty until it reaches the ground. And so as a result, it's not a case of kimle d'rabba mineh, because at the moment of the sale, he's subject to the 4 times or 5 times penalty, and he's only subject to the death penalty when the animal lands. So as a result, they're not at the same time, and therefore you would not be exempt. So that case doesn't work according to the rabbis. So we can make it work according to the rabbis, because we can say, "Ba'omer lo tikni le gnebuseich ad shetanuach," because we can say that the buyer said that, listen, until it lands in my yard, that's when I'm going to take possession of it. So as a result, when it lands in the yard, it is both the moment that the thief has violated Shabbat, because that's when it has landed, and it's the moment that the buyer has acquired it. And so as a result, we've now found a case where the buyer has a good transaction, and it violates the Torah at the same time, and therefore is subject to the death penalty, and therefore is subject to kimle b'derabba mineh, and therefore is not going to be subject. The thief is not going to be subject to the 4 times or 5 times payment. Rava Amar la'olam kirami bar Kamma. Really, we can even say like Rami bar Kamma. And how do we explain, again, when Rami bar Kamma said that we're talking about with a person who cut the fig off the tree? So what do we do about the fact that it's not a transaction that would be enforced in the court of law? We can give you another analogy. And this is an awful analogy, I admit, awful in the sense of what it's talking about, but here's the analogy. Esnan. Esnan is the payment for a prostitute. Esnan, usra Torah. The payment for a prostitute is prohibited in the Torah for using as to purchase sacrifices in the Beit HaMikdash. Va'afilu ba'alimo. Even if the wage that is being paid is in order to where the prostitute is the person's mother. Meaning, and why does that matter? Because Kamma bedina, because if the mother tried to sue her son for the wages that she was supposed to get as a prostitute for their having relations, would we actually give her the payment? Of course not. Because we wouldn't, because the son is subject to the death penalty for having had relations with his mother. So Ella Av al Gav Katava Le Bedina Lo Amrina Le Zil Havla. Because, and so that shows that even though we won't necessarily enforce a transaction, if he actually did give her the money, Habi Esnan, we would still consider it the payment for a prostitution. So Hachinami. Aval gav de le'inyan tashlumin itava bedina kaman lo amrina le'zil shalem. Even though if the person who cut the fig refused to give the sheep, we would not tell the thief that he has to give the sheep to the buyer. We wouldn't tell him that. But nevertheless, afilu hachi kaven de kamakni le'bahachi. If in fact he did transfer the animal for the fig, havya mechira. It's a good sale. And therefore, it would be a case of kimle b'derabba mineh. And so, even though we wouldn't enforce the sale in a court of law, we're going to say that if they agreed to the sale and they performed the sale, it's a valid sale with respect to the law of paying dalid v'hei. But even though it's a valid sale with respect to paying dalid v'hei, it's not a valid sale. It's not going to make a difference because you're subject to the death penalty, and we won't put you in the category of having to pay 4 times or 5 times for selling a stolen animal if you're also subject to the death penalty because of the principle of kimle b'derabba mineh, the fact that we only apply the most severe penalty. So, all right. So our Mishnah, we learn now the first case of our Mishnah of stealing and selling an animal and selling it on Shabbos. What about all the other cases? Well, of course, for that, you'll need to stay tuned. Tomorrow, I think we're only going to deal with one of those cases, but we'll stay tuned for the next few days as we go through the rest of this Mishnah.
How can they say it's stolen and a stolen object is even a valid sale?
Yes, that's exactly right. Raise an excellent question, meaning how is it possible that the sale is a valid sale given that it's a stolen object? And so there we answered there are a couple of different ways that we can answer it. So according to some, you would need to actually have, and this was the debate that we've had basically over the last week. We had the debate as, do you need to have had a yayush before the sale in order to make it valid? Or do we say no, just having the sale is enough to make it a sufficient thing? Because we have the concept that when it changes possession from the ownership of the thief to somebody else, that in and of itself is an act ownership that will actually be considered valid. So it's the only when you have the transfer, or alternatively, I'm trying to think. That we'll say that yes, you may be right that it's not a valid transfer, but in fact, even though it's not a valid transfer, the fact that you did it will credit it as if it was a valid transfer. So there were three different approaches, if I remember correctly, that we found in order to explain why, even though ordinarily, if somebody steals something, they have no right to sell it. We're going to say that if they stole an animal and then sell it, we're going to still treat them as if they are subject to the 4 times or 5 times penalty. Because you're right. Maybe, well, why should it be ever a good sale if you're selling something that doesn't belong to you? So, but nonetheless, we're going to say that even though it's not something that belongs to you, when you try to sell it or effect the sale, we're going to say that it's sufficient to cause you to be subject to the 4 times or 5 times penalty. You look like you still got to process it.
Yeah, I mean, I hear this, but nonetheless, if someone said, if the other party is acquiring, the quote unquote purchaser is acquiring stolen property, and you can
Correct.
say, well, yeah, it changes hands, but it's still stolen property. So in the end, I mean,
yeah. So I totally hear you. And totally understand exactly your point. And according to some, the victim would still be able to collect it from the purchaser of the thief, but for the purchaser, the stolen item, and that would be, you're exactly right. They would be able to collect it, but it's not a universal viewpoint. The point is that some people would say that once you have a valid sale, especially if the purchaser doesn't know that the item is stolen, that would be sufficient, especially when it comes to metaltalin, when it comes to movable property. And therefore, and that's why, and of course, we're talking about movable property because we're talking about animals. And so as a result, that's why we're going to say, yes, you're absolutely right that the thief doesn't have a right to sell it. But once it goes into the possession of the purchaser effectively has full ownership rights to it, and the only claim that the victim would have is against the thief, and that's part of the reason, according to Shadal, Shmuel David Lusato's commentary on this in the Torah. That's the reason that we're going to make this an extra penalty, because it's limiting the ability to try and catch the thief, because the object of the theft is going to have disappeared from the hands of the thief and possibly have disappeared from the world if we're talking about slaughtering and eating it. So you're exactly right that the even though the purchaser has purchased something that's has purchased stolen goods, in general, we will say that when the purchaser purchases stolen goods, and we haven't really fully explored this. I think I know that we're going to continue to explore this item as we move forward. The purchaser maybe have the right to be able to retain it, especially if he didn't know that it was a stolen item. And so as a result, even though the thief didn't have the right to sell it, it's still a sufficiently valid sale such that we will charge the person with the 4 times and 5 times penalty.
Yeah, okay.
Yeah. All right, we got it. Gonna still have to think about it. And again, like I said, this is a very this is why this chapter is so complicated and deep. So I wish God willing, we'll continue to be learning it together, and hopefully we'll be able to explore and see some of the further concepts that will help make it more easily understandable how a sale that maybe is not even a valid sale can really trigger the 4 times and 5 times penalty. Looking forward to continuing our learning together.
Okay.